So ये जो topic है, uh, this needs no introduction, right? Because we all have been following this news. India and Pakistan, they were close to the real war, right? Okay, so armed conflict तो हो ही गया था, but they were really close to the war. But before that, ceasefire was signed and was also violated. Then again, signed. So a lot of things have happened, but the focus during the entire conflict, during the entire news of the conflict has been on the events related to the conflict, like who is attacking, which part of the country, what are the weapons being used, all of that. But one thing that we must know out of this topic is the legal implications or the laws related to the India-Pakistan conflict. That is important for us, right? Because it becomes an essential part, especially if you're preparing for Clat and you have there is a section called legal aptitude, which is also dominated sometimes by legal current affairs. तो उसमें ये important बन जाता है आपके लिए इस टॉपिक से रिलेटेड जो इंटरनेशनल लॉ है, क्योंकि यहाँ पे डोमेस्टिक लॉ अप्लाई नहीं करेगा. Whenever there is a dispute between two state parties refers to countries. Whenever there is a dispute between two countries, then the domestic law will not apply. International law comes into picture, right? Now, international law has many aspects, and in today's session, we will see what all aspects are there. How does international law really govern the disputes between two countries? Okay. Currently, there is a dispute going on between Russia and Ukraine, which is also being governed by international law. India, Pakistan definitely being governed by international law. And in past also, whatever disputes have happened among the states, especially after 1945, since we have United Nations, since then the disputes are being governed under international law. But one problem with international law is that it is not a very strict law, right? For instance, domestic law is binding, and there are mechanisms, there are authorities which make it binding on you. But international law is slightly different. The member states, if they sign, if they choose to be bound by the decisions of the International Court of Justice, ICC, only then they are bound by it. Otherwise, if they voluntarily decide not to be bound by the decisions of international law, then they are not bound by it. And interestingly, India and Pakistan, neither of them have submitted to be bound by the rules of international law. So that again is a problem, that why United Nations could not do much during the conflict. Anyway, so we will see. We will look at the legal angle only, and from what passages you can expect questions, from what topics you can expect passages and questions in your exam. We will look into all of that. So first thing is use of force. Use of force के बारे में पढ़ना important है. What is use of force? Let's see. The starting point for evaluating any military action under international law is Article 2.4 of the United Nations Charter. Now, here comes one provision which becomes important for you for Clat. There could be a potential passage on this provision. United Nations Charter is the that code which defines limitations and rights and all of that. तो उसके अंदर clear prohibition है. You have to see Article 2 Clause 4. Everything starts from here. All states, whether they are currently facing dispute or are going to face dispute in future, they have to keep it in mind that there is this Article 2 Clause 4, which says the threat or use of force against the territorial integrity or political independence of any state is prohibited. Threat or use of force. Okay? So this is clearly telling कि international law इस activity को support नहीं करता है. International law never supports any activity of armed conflict or violence or war for that matter, and that is given to you under Article 2 Clause 4. Okay. Now, what happens is, what does this mean? Does this mean that if somebody attacks me or somebody attacks my country, then I will not even respond? The answer is no. Clearly, it is no, because it talks about that you will not be the aggressor. Not to be initiated. Okay. What is prohibited? What is prohibited is you are not going to initiate it. But in case somebody is attacking your country, then what rights do you have? Let us see. Now you see, there are two exceptions. Again, जो पैसेज में बोल रहा हूँ, आर्टिकल 2 क्लॉज 4 यूएन चार्टर से पैसेज बन सकता है, लीगल का क्वेश्चन बन सकते हैं. Those provisions will come along with the exceptions. So there are two exceptions only to this rule. मतलब in what situations can you attack? In what situations can there be an armed attack? Right. The first condition is self-defense, which we have studied probably in criminal law also. If you have done criminal law. Yes, Sanskriti, very good. If you have studied criminal law, torts for that matter, then you must have known self-defense, private defense, all of that is permitted. So self-defense under Article 51 of again what of the UN Charter, Article 51 of the same charter allows for private defense. Now we have got two provisions to understand. Article 2 plus 4, which prohibits the use of force or threat against any state, right? But but if there is any armed attack, if there is any violent attack on another country, for self defense they can use it. तो इसका नेचुरल सा मीनिंग क्या हुआ कि one country will be violating article 2 clause 4, right? One country will be violating or breaching article 2 clause 4 of the UN charter, and the other party will be responding to it, right? So that response is prohibited, sorry, the response is protected, permitted and excused under the international law. दूसरा है यूएन सिक्योरिटी काउंसिल का ऑथराइजेशन अंडर चैप्टर 7. नाउ समटाइम्स व्हाट हैपेंस इज दिस इज अनदर before any attack could be carried out, before any armed attack could be carried out, यूएन सिक्योरिटी काउंसिल का परमिशन अगर आपके पास है, if you have it, लेना जरूरी नहीं है. Try to understand, it is not mandatory, but if you have taken it, then again you get the right to violate article 2 clause 4. So it can be violated in only two circumstances: private defense or the consent of UN Security Council, which has the highest authority to control wars and disputes between the states, right? So understand this provision. ऐसा हो सकता है कि you get a passage only on article 2 clause 4, then you don't have to apply this, or there could be a passage which gives you rules and exceptions together, then you have to have a conclusive opinion on that law. All right. So now, if you look at what did India do? Operation Sindhu. What is the legal validity of Operation Sindhu? Ananya. But countries who are not the part of international law will this, so that it does not apply to them. That's what I'm saying. Countries which are not part of international law, that's the problem with international law. What happens if you violate an international law? At max, you are boycotted from the international community, and all the support, all the funding is taken away from you, and then you're left isolated. That is ultimately what international law can do. But international law doesn't really have the authority to bind people just like a normal domestic law. We'll come to that in a later while. When will the UNSC authorize to use force? Again, in the same case, when there is a threat to use force, when there is an armed attack possibility, when the attack is the only remedy left, only option left, right? In that case, they can definitely allow. Anya, is that okay? Now you see कि हमारा जो अटैक था, इंडिया का जो अटैक था सेल्फ डिफेंस का, वो India has said it is self defense, but is it really self defense is the question. Is it really self defense? Let us see. So this is the right of self-defense. You can go through this. Article 51 of the UN Charter states that nothing impairs the inherent right of a nation to defend itself in an armed attack occurs. So India says we carried out self-defense activities, our response was self-defense, but for self-defense there has to be an armed attack. So the first question that arises is whether what Pakistan did in Pahalgam was an armed attack. That's the first question. If what happened in Pahalgam was an armed attack, then India would have had the right of self-defense. So what is an armed attack? We'll look at that also. But self-defense के अंदर कुछ चीजें होनी चाहिए. First of all, कोई peaceful alternative नहीं होना चाहिए. It should be the necessity, to save yourself. Proportionality होना चाहिए, limited to what is needed. So proportionality, India had this proportionality definitely. Because we only targeted the civilians, we did, sorry, not the civilians, only the military, the terrorist bases, not even the military bases for that matter, or civilians. So proportionality. Attribution is very important. the attack must be traceable to a state or actors under its control. Now you have to understand, this is where India's position is little weak. This is where, I have to say this because see, I'm analyzing this legally. I'm not analyzing this from the point of view of a patriotic citizen or a person like that. I'm analyzing this legally in an unbiased manner. The position of India is questionable, is being criticized on this ground, which is the attack must be traceable to a state or actors under its control. Matlab, if India says that we want to carry out private defense against Pakistan, then India had to prove that the state of Pakistan, that is the government of Pakistan, the officials of Pakistan government have carried out an armed attack against us. So either the state has to carry out, or the actors in the sense people who are part of state, government departments, for example, military is a part of state, right? So अगर state ने अटैक किया है तो प्राइवेट डिफेंस होता है. But the question here is that whether a private actor, whether any entity, organization which is not a part of the state, for example, a terrorist organization which is not really a part of the state, at least not directly. So, if there is an attack from the terrorist organization upon a country, can the country say that it is now responding as a self defense? And you know the rule. रूल इज स्टेट का अटैक होना चाहिए, देन यू हैव प्राइवेट डिफेंस. तो ये क्वेश्चनेबल सिचुएशन है, थोड़ा इंटरनेशनल लॉ के अंदर ग्रे एरिया है, डिस्प्यूटेड एरिया है, बिकॉज पाकिस्तान सेज दैट it was carried out by terrorist organizations not related to the state of Pakistan, not related to the government of Pakistan, right? But I will let me first explain the entire concept. You will get all your doubts clear. ठीक है, पहले बात समझ लो आप. सो क्वेश्चनेबल क्या चीज है? रूल कहता है कि स्टेट अपॉन स्टेट आर्म अटैक होना चाहिए तो सेल्फ डिफेंस मिलेगा. बट पाकिस्तान सेज दैट टेररिस्ट ऑर्गेनाइजेशन था, स्टेट ने इंडिया के ऊपर हमला नहीं किया था, इसलिए इंडिया हैड नो राइट ऑफ प्राइवेट डिफेंस. दिस इज व्हाट देयर आर्गुमेंट इज. एंड आवर आर्गुमेंट इज दैट we had a threat from Pakistan and therefore we had to carry out the responsive armed attack. So that is the question. Let's understand this properly. Now, ये इंडिया का कहना है कि even though the terrorist activity was not directly a part of Pakistani government, but the terrorist groups are being supported by the Pakistan government. This is what India asserts. Now the point is that these things are simply assertions or claims made by the Indian government. As of now, no credible, substantial, unquestionable proof has been brought. Yes, there are some instances which definitely suggest a strong indication towards the link of Pakistan as a state to the terrorist organizations. But still, दोनों states के पास, दोनों states का अपना अपना एक claim है, and as of now there is no consensus on that. India and Pakistan have not agreed on this point that terrorist activities are being carried out by Pakistani government through the terrorist or under their supervision. There is no agreement on that as of now. Both the states have their different claims. Now, let's look at ceasefire. Ceasefire क्या होता है? So ceasefire के बारे में आपने सुना होगा. Ceasefire is an agreement to stop the fire or to stop the armed operations, army operations. So ceasefire is also legal, is a legal concept, is an international law concept. उसको भी govern किया जाता है. Ceasefires are binding political or legal agreements to suspend hostilities, right? These are binding agreements. See, this is an agreement, not a law. It is not a law, but it is an agreement. So only if parties are interested in executing an agreement of ceasefire, तभी होगा. कोई भी force नहीं कर सकता. No third party can force two countries to sign a ceasefire. It is voluntary done. ठीक है? और हमारा ceasefire जो है वो reaffirmed हुआ है. First, we have done similar agreement also, after the 1971 war, we had done similar agreement also. So that is also an agreement of ceasefire. But we have reaffirmed it in 2021, right? And the breaching ceasefire it violates humanitarian law. Civilians are harmed. So if civilians are harmed, it is a violation of ceasefire, which is why the India says that Pakistan first violated the ceasefire by attacking Pahalgam, in Pahalgam. Okay, but मैंने बोला कि वो भी questionable है. We will have to see how legal is that. ओके, दूसरा सीज फायर का वायलेशन कैसे होता है कि बायलैटरल ट्रीटीज है, जैसे शिमला अग्रीमेंट है या और भी कोई अग्रीमेंट है, उसकी किसी कंडीशन को आपने फुलफिल नहीं किया तो सीज फायर जो है वो वायलेट हो सकता है। ठीक है, नाउ सीज फायर को गवर्न कौन करता है? इट इज वेरी इंपॉर्टेंट टू सी who exactly governs the ceasefire. So there are customary international humanitarian law. This is Red Cross Society and Rule 36 particularly talks about ceasefire. So ceasefire is a legal concept, has a legal backing, and is regulated in international law. Geneva Conventions है, Common Article 3 है, UNSC का resolutions है, resolutions are the commitments. Okay, and then there is Shimla Agreement. So there are so many. I mean, this is in particular to India and Pakistan, but these are the general provisions applicable on the whole world. So ceasefire uh, is valid. An agreement of ceasefire is only valid when entered into by both parties. Third party कहने से कुछ नहीं होता है, ठीक है? दोनों पार्टीज को अग्री करना पड़ेगा, जो कि इंडिया और पाकिस्तान ने किया था, एंड पाकिस्तान had again violated this. Now this is a concept that I want you to have attention, to give your complete attention to, which is in support of India. Let me be very honest with you, right? Because I'm giving you an unbiased legal analysis, and आपके पास भी जब एग्जाम में क्वेश्चन आता है, in case there is a passage, don't be biased towards or against any country. Read the passage and analyze the facts of the passage of the question in an independent manner. Apply the law, come to a conclusion. Even if that conclusion goes against Indian military action, even if it goes against that, you might have to choose that as an answer, because our focus has to be to follow the law, right? Not the emotions. uh, Ceasefire is any agreement to stop firing or stop the armed attack or armed activity. Okay, so ceasefire is only valid when there is a clear agreement, either verbal or written, between the parties. ठीक है, तो ceasefire, लेकिन ceasefire is not an obligation that you have to enter into a ceasefire agreement. You know what is ceasefire agreement, right? Have you understand that, Alvira? राइट, सो सीज फायर एग्रीमेंट जो है वो अगर पार्टीज अपनी कंसेंट से साइन करती हैं तब वैलिड होता है, और सीज फायर की वायोलेशन होने पर को भी एक माना जाता है रीजन फॉर सेल्फ डिफेंस। ओके, तो वायोलेशन ऑफ सीज फायर कैन आल्सो अमाउंट टू द कॉज ऑफ सेल्फ डिफेंस। नाउ यू अंडरस्टैंड इट? Yes, UN is a third party, so ceasefire cannot be forced upon states by a third party. Like I said, it is a completely voluntary thing. So it's like an agreement between two persons. Forget about ceasefire. Let us talk about a contract. So whether two people want to enter into a contract with each other or not is a matter of their own discretion. Am I correct? Can a third party come and force them to enter into an agreement with both of them? No, right. Similar to that, ceasefire is also voluntary choice on the part of countries. But if at all they want to enter into a ceasefire agreement, then we have the laws which regulate the ceasefire agreement, which tell us that what is a valid ceasefire agreement, when ceasefire can be violated, what can be done if it is violated by one state. Are you getting the point now? नाउ ये जो कॉन्सेप्ट है इसको बहुत ध्यान से समझना, क्योंकि हमारा जो इंडिया रेस्पॉन्सिव आर्म्ड अटैक इज सपोर्टेड बाय दिस डॉक्ट्रिन, अनविलिंग और अनेबल डॉक्ट्रिन। इंडिया का पोजीशन यहां से स्ट्रॉन्ग होता है। ठीक है, मैंने बताया था वीक कहां से होता है। वीक कैसे होता है कि इंटरनेशनल लॉ के अंदर प्राइवेट डिफेंस आपको तभी मिलता है जब आपके पास या तो यूएनएससी का कंसेंट हो, जो वहां पास नहीं था, या फिर आपके ऊपर आर्म्ड अटैक किसी स्टेट ने किया हो, जो कि पाकिस्तान मना करता है। ठीक है, नाउ ये जो डॉक्ट्रिन है ये डेवलप हो रहा है, इंटरनेशनल कॉन्सेप्ट में डेवलप हो रहा है, थ्रू एग्जांपल्स ये डेवलप हो रहा है। इसका मतलब क्या होता है कि सेल्फ डिफेंस अगेंस्ट नॉन स्टेट एक्टर्स। तो यहाँ पे वो जो टेररिस्ट ऑर्गेनाइजेशन हैं, जो कि प्राइवेटली रन ऑर्गेनाइजेशंस हो सकते हैं, या स्टेट फंडेड हो सकते हैं, या नॉन स्टेट फंडेड हो सकते हैं, उससे मतलब ही नहीं है। एनी नॉन स्टेट एक्टर, when the host state is unwilling or unable to prevent them, India argues, ये इंडिया का आर्गुमेंट है, that Pakistan is an unwilling state, or is an unable state. Pakistan. So let us imagine a situation. एक कंट्री है जहां पे लेट अस से कि इस तरह के रेबल ग्रुप्स हैं, ठीक है, एंटी स्टेट ग्रुप्स हैं जो कि एंटी रिलीजियस भी हो सकते हैं या दे माइट बी कैरिंग आउट वायलेंट एक्टिविटीज अगेंस्ट अदर countries. For example, if I talk about Khalistan, so Khalistan, some people supporting Khalistan are also living in Canada, right? So if tomorrow Khalistanis attack India or some part of it, can we say that Canada has attacked us? So the answer will be depending on this fact whether Canada supported Khalistan movement directly, indirectly or not. तो हमारा आर्ग्यूमेंट ये है कि पाकिस्तान टेररिस्ट ऑर्गेनाइजेशन को सपोर्ट करता है, which is a non-state actor, and that's why Pakistan becomes an unwilling or unable state. ठीक है, और इस वजह से हमारे पास राइट टू सेल्फ डिफेंस आता है, ठीक है। लेकिन ये डॉक्ट्रिन कंट्रोवर्शियल है, जैसा मैंने बताया है। कंट्रोवर्शियल क्यों है? क्योंकि इस डॉक्ट्रिन को यूएन का या इंटरनेशनल कम्युनिटी का सपोर्ट नहीं है। एज ऑफ नाउ इंटरनेशनल लॉ इज रियली साइलेंट ऑन दिस। मैं उसी पे आ रहा हूँ। इंटरनेशनल लॉ इज रियली साइलेंट ऑन दिस, बट इट हैज बीन डन बाय सेवरल स्टेट्स इन द पास्ट। And like I told you, international law is not really a hard law. It's not really a binding law. Okay, so it only makes suggestions and instructions and directions. और उसको ना फॉलो करने पर ज्यादा से ज्यादा आपका इंटरनेशनल कम्युनिटी में बॉयकॉट हो सकता है ना। उससे ज्यादा कुछ खास हो नहीं सकता। तो ये कॉन्सेप्ट भी डेवलप हो रहा है और ये इंडिया का आर्ग्यूमेंट है। बट लुक एट वन थिंग, दिस कॉन्सेप्ट, although India is being criticized on certain grounds legally, but still you see the whole international community has supported India in this event, right? So we can say impliedly, indirectly, the international community is accepting this doctrine, क्योंकि हमारा जो बेसिस है वो यही डॉक्ट्रिन है, बिकॉज हमारे पास कोई प्रूफ नहीं है दैट द स्टेट हैज रियली अटैक्ड अस। एनीवे, अभी हम देखते हैं न्यूक्लियर। Can this doctrine apply when non-state actors are being funded, because then it will be a conflict between both state and non-state? Yeah. So no, if there is any terrorist organization, if there is any terrorist organization which is being supported by the country, by a country, then obviously basically this is an exception to the rule of private defense, and I mean it is developing as an exception. देखो इंटरनेशनल लॉ के बारे में एक बात समझो कि इंटरनेशनल लॉ को कोई बनाने वाला है नहीं। देयर इज नो इंटरनेशनल पार्लियामेंट एज सच, राइट? तो जैसे इंडिया में तो पार्लियामेंट है तो लॉ बना देती है और फोर्स को एनफोर्स करवा देते हैं अपन। पुलिस का सिस्टम है, जजेस का सिस्टम है। इंटरनेशनल लॉ इन चीजों पर वीक रहता है क्योंकि वो मेंबर्स की कंसेंट पर डिपेंड करता है बहुत ज्यादा। सो प्राइवेट डिफेंस का एज एन एक्सेप्शन और एक नया डायमेंशन इवॉल्व हो रहा है जिसमें इंडिया हैज बिकम पार्ट ऑफ दैट डॉक्ट्रिन। प्रीवियसली some disputes have happened where this was used, right? और उसको universally accept भी किया गया था, and this time also it has been accepted, okay? That what India has done. So this is what is the current situation. It is developing as a concept, but is not a well recognized concept of United Nations. Do you get this point, everybody? यहाँ तक समझ में आ रहा है? वेरी गुड, ठीक है। तो इंडिया रेस्पॉन्सिव अटैक I would say was necessary, fine, but not 100%, not 100% legal, but not 100% illegal as well. Okay, all right, you get that point according to the law. Now, अब हमने ये भी देखा था न्यूक्लियर वेपन। Now there is a threat. There is a threat coming from states, you know, even right now Russia and Ukraine are undergoing a dispute, so there has been a constant set of nuclear weapon discharge. Even I think during the India-Pakistan conflict also Pakistan had threatened, or maybe there were rumors like that. So what is the status of a nuclear weapon? Can it be used just like that? Is there any law? Is there any you know, charter or resolution that governs nuclear weapons, because it's considered to be the highest form of weapon which can cause irreparable amount of damage? Then definitely yes, there is definitely provisions related to that. You can go through this once and I'll explain. So it is undoubtedly true कि दोनों के पास न्यूक्लियर वेपन्स हैं. But interestingly, you see, there is a non-proliferation treaty. Let me write down its full form. Non-proliferation treaty. मतलब, it is a treaty, and a treaty is basically an agreement between the states. So what is a treaty? And a lot of countries have signed it, but a lot of countries have also not signed it. Okay. Non-proliferation treaty is an agreement, is a submission, is a consent that nuclear weapons will not be used. But interestingly, India and Pakistan have not signed it because they both have threats from each other, and therefore they are not really sure whether they will use nuclear weapons or not. So they can't give that commitment. Okay. So since India and Pakistan have not signed the NPT, that means nuclear weapons can be used. That's for sure. But look at the other advisory. In 1996, the International Court of Justice said use of threat of nuclear weapons is generally illegal, but uncertain if used in self-defense when survival is at stake. Very important. जब survival stake पे हो जाएगा, वही वाली बात है कि nuclear weapons, you will not initiate the release of nuclear weapons. You will not start the attack with nuclear weapons. But if there is a nuclear attack, or if there is an attack of similar level, जहाँ पे tremendous amount of damage can happen, and जहाँ पे survival is at stake, मतलब और कोई option आपके पास बचा नहीं है, your military is unable to control the harm, or otherwise, then nuclear weapons can be used by the state. तो ये opinion है. Again, you look at this, it is an advisory opinion, does not really have binding force. The whole problem with international law is it does not have binding force. In most cases, it does not have binding force. That's the main problem, and that is why we see disputes between the states all the time. But anyway, threatening nuclear use may breach the UN Charter. That is also true. कि अगर आप सिर्फ यूसेज बैन नहीं है, अगर कोई थ्रेटन भी करता है तो भी वो यूएन चार्टर को ब्रीच कर सकता है. I told you, right, Anya, if nuclear weapons are used, वैसे तो मना है, it is prohibited, you can't use nuclear weapons. But if somebody uses it, then सामने से, I mean, if country A uses nuclear weapons, then country B gets the right to use nuclear weapons in response to that. Right? Is that clear? What is your question, Anya? The last line is threatening nuclear use. So nuclear usage जो है, वो तो मैंने आपको बताया था कि एनपीटी जो है नॉन प्रोलिफरेशन ट्रीटी और एडवाइजरी ओपिनियन है, इसके अकॉर्डिंग प्रोहिबिटेड है न्यूक्लियर यूज अनलेस सर्वाइवल इज एट स्टेक, राइट? आई मीन nobody can start the nuclear attack, but whether the threat of nuclear attack is also prohibited, then on that the law is unclear. The law is actually unclear कि अगर कोई स्टेट दूसरे स्टेट को थ्रेटन करता है कि न्यूक्लियर वेपन्स का डिस्चार्ज हम कर देंगे या वी विल यूज न्यूक्लियर वेपन, वेदर इंटरनेशनल लॉ गवर्न्स दैट और नॉट इज क्वाइट अनसर्टेन. एज ऑफ नाउ उसके ऊपर सर्टेनिटी नहीं है. ठीक है. तो जो एनपीटी है, एनपीटी इज अबाउट नॉन यूसेज, इट इज नॉट अबाउट नॉन थ्रेटनिंग ऑफ न्यूक्लियर वेपन्स, राइट? तो इंडिया पाकिस्तान डिस्प्यूट में ये भी there are a lot of violations also, on the part of Pakistan, because first thing is that they have not publicly said that the attack on Pahalgam was carried out by a non-state actor. They've not said it they've not said it openly, right? So they've left that scope open for interpretation. And secondly, they've threatened India to use nuclear weapons, which is the law on that is not clear. That's the problem, right? But anyway, we just have to understand the international law. International law, आपको बस just read the provisions, try to understand its implication, interpretation. That's it. I mean, don't think that international law is a very hard sort of law. It's not like that. Okay. Now, what exactly is a war? What exactly is a war in international law? So, international law uses the term armed conflict rather than war. Now, that's an important piece of information for you. That war is something that we as common men, common people live and use, right? But international law does not say that it's a war. Okay, they instead use the term armed conflict. Okay, so in war, it is necessary to involve arms. If so, there is a dispute between two countries of greatest level, but there is no use or involvement of arms as such, does not become an armed conflict, right? So I think yes, it is better to uh, define the concept of war, and it is governed by two provisions, mainly Geneva Convention 1949 and customary international humanitarian law. This is humanitarian law. Okay. Now, what you have to do is why I'm taking this session. It is a referential, session where I introduce to the topic. I introduce you to the topic, and I give you ideas of where you can expect passages from, what kind of topics can come up. But this is not it. What you are expected to do today or tomorrow is that do research on these topics that we have discussed, subtopics. For example, international humanitarian law, use of nuclear threat, all of that. Okay, do more research about it. Do read about it. Read the laws around it. Read the provisions around it. Because Clat is an exam that will test you on your reading ability. It will not test you on your knowledge. Okay, it will not test you on how much you know or are you aware of. It will test you how well you understand the law. So I would suggest all of you to go through each of them points in the in the research format. Okay. So war क्या होता है या armed conflict क्या होता है? Let's look at that now. See, intense, prolonged violence. Very good definition and a very precise definition. Intense is severe, and prolonged violence. Prolonged means for quite a long time. For quite a lot time. So, is it right to say that India and Pakistan just had a war? What do you think? According to this definition, did India and Pakistan had a war? Very good. We were close to the war. I started this session by saying that we were close to the war, but it was not really a war. It was not really an armed conflict in the real sense because it was intense, definitely, but it was not prolonged violence. It went on only for a few days, right? It was not prolonged violence. So definitely not the war. And even with the involved states or organized armed groups, ये already clear है कि या तो states होंगे या organized armed groups भी हो सकते हैं which are backed by the state. Even without a formal war declaration, cross-border military actions can amount to armed conflict. So formal declaration of war जरूरी नहीं है. Cross-border military actions. This is what India and Pakistan did. There was no official declaration of war or armed conflict, but both were, firing at the borders, and therefore there is no necessity of declaring a formal war. But fortunately, that did not happen. That line was not crossed because it never was prolonged. And intense भी हम सही सेंस में बोल नहीं सकते. It was not that severe. I mean, if you look at other examples like Russia and Ukraine at the moment, so yes, that can be said to be a serious, severe incident. Yes, Gokul, what is the doubt? What is the doubt? Yeah. Yes, you can say that. You can say that. Now let me come to the questions. I think I missed a few questions. Uh, so what is Geneva Convention? It wasn't possible for me to cover Geneva Convention in this slide, but I'll come up with this for sure in the next one. And meanwhile, you have to research about it. Like I said, it is a referential video that has given you an idea of what you should be doing to better legal reasoning and how to anticipate टॉपिक्स बिकॉज हॉट टॉपिक है और लीगल करंट अफेयर्स से रिलेटेड है इसलिए फॉर रेफरेंस वी हैव डन दिस बट यू हैव टू डू अ रिसर्च ऑन अ फ्यू टॉपिक्स एंड ट्राई टू रीड दोस टॉपिक्स जितना ज्यादा आप पढ़ोगे उतना ज्यादा बेनिफिशियल आपके लिए होगा Anya, but when countries are at war, then do they have the right? What right are you talking about, Anya? Okay, I think the question has gone back. Hmm. Okay. Am I missing anybody else's question here? Or if you have any question, post it. Then I have a few things to share once again. A few areas we have covered. Yes. Anya, you're right in that. I told you, right, Geneva Convention will come up in the next session because that needs a separate study. Okay. किसी और का डाउट पेंडिंग है? What is a PMC? Somebody has posed a question if a PMC attacks. Yes, we will look at that in the end. No, you don't worry. So Alvira has a question: if two countries are at war and one volunteers for ceasefire but doesn't agree to it, what can the country do? Nothing. Nothing. That's what I'm saying. No third party or no stranger to the dispute can force any state to sign the ceasefire, to enter the ceasefire. That's what I'm saying. Ceasefire is a voluntary decision which is left at the choice of the state. You can only suggest, you can only make recommendations to the state, but whether the state will go for it or not will depend on the state itself. Okay? Is that point clear? So nothing can be done. Alvira. Yes. Yes, the Shimla agreement was a ceasefire. Yes, that's exactly what I'm saying. The Shimla agreement had a lot of things. The Shimla agreement had basically also fixed the line of control. You know that it also demarcated the areas where Pakistan would have rights and India would have rights. We clarified them and also had a ceasefire agreement in the same agreement, right? You don't need to have a ceasefire. You can have a ceasefire agreement separately. You can have it included in a different document which has multiple other provisions as well. Whatever is the need of the hour, whatever best can be done, it is done accordingly. So at that moment in Shimla agreement, ceasefire agreement is there. Yes, that's why, and which was reaffirmed in 2021, right? But a vote was held in the UN when the Russia-Ukraine war broke out to make Russia retreat from Ukraine, which was vetoed by Russia. Yeah, so see, because those are different, that's a different issue, Gokul. We're not going that way. We are only considering that, the India and Pakistan's conflict, how is it affected or dominated by the international law? Okay? And Russia-Ukraine is a separate issue, which will be covered separately. Don't worry. Yes, suspending the treaty was yes. Because when there is a ceasefire, see, when there is a ceasefire agreement, the violation of ceasefire agreement also leads to many retaliatory activities, and especially if those activities are peaceful. Okay, so in that sense, yes, suspension of treaty was rightfully done against the breach of ceasefire. Okay, yes, that issue will Anshika will be, it will also be covered separately because that forms a part of a separate dispute. Now let's what is the final legal position? Let's look at that. The final legal position is that it is complex. Complex intersections of modern international law. Why is it complex? Because I will talk about it again. Because Pakistan says that we did not carry out the attack. I mean, openly they've not said it, but yeah, that's what their assertion is. And India says that it is private defense, but private defense cannot be used unless there is an armed attack from a state. So both parties have presented complex arguments or factual situations, and because of which we can't really figure out who is 100% legal and who is not 100% legal in that sense. But yeah, so India's approach, I told you, is already a mixture of established doctrines with emerging norms. I told you the emerging norm was unwilling state or unable state, which is still an emerging doctrine. And this is the only support that we find in international law for us. Number one. Number two, this doctrine is not written anywhere, but is being accepted by a few countries and has been done in the past also, and is probably going to be done even more so in future. And especially, you know what, India has clearly given this statement that if there is any act of terror in future, if there is any act of terror in future, it will be considered to be an act of war, or it will be considered to be armed attack against India. So India has made it very clear that we are going to follow the unwilling doctrine for sure. Okay, despite severe criticism, India has not backed out. India has said that we will follow unwilling doctrine no matter what. So we will see, maybe this doctrine gets converted into a proper established norm in future. Yet to see that. Okay. The evolution of legal landscape here may influence how. Yes, that is also true. Because international law is more about precedents, right? So what precedents are set? Precedent is a prior approach. Prior approach. मतलब something, a certain approach which has been decided previously is called precedent. So India has also set a precedent and is also, and other countries are probably going to follow that. We will see that in more time. Okay. So this is the basic of legality. We can have a recap. Whether the dispute, whether India's or Pakistan's action were legally correct or not, I would say is complex to understand. And both countries' actions can be challenged and supported in different ways. So uh, there can be no one-liner given either for India or for Pakistan whether the response was legal or not. One-liner should not be given. I think let's wait for this concept to be developed more, evolved more, and yeah, and just look at this from the perspective of potential legal passage in your exam. Just follow the law. Okay, don't follow what your heart says. Follow what the law says. Terror will be called. No, it will not. It will not be called act of God. So he might have said it. He must have some other provision, some other legal provision, because एक इंसिडेंट को गवर्न करने के लिए काफी सारे प्रोविजंस होते हैं, काफी सारी ट्रीटीज होती हैं. So maybe he's relying on a different provision, and India is relying on a different provision. Sometimes there is a conflict of provisions also. Sometimes there is a conflict of laws also, right? So it may be a case of that. Okay, so I am showing 1 second. You can, for the previous slides, this was the starting slide. Kritika. So see, you can expect a passage on this. You know, you will in legal reasoning, you will not be this session is aimed at legal reasoning. This session is not aimed at building your current affairs or GK. It is aimed at giving you potential topics and brief understanding to handle passages based on international law. Because this year, you know, international law is in news constantly. First because of India and Pakistan, and now because of Russia and Ukraine. So you must cover this topic. And with time, I will also keep coming up with more legal analysis of different international aspects. A lot of aspects, uh, a lot of aspects were not covered in this session, and it's not possible to cover every aspect in one session. So we will need more such sessions, and uh, I hope we will get enough information on that, right? So thank you so much, and I'll see you again. I'll see you again very very soon with more relevant, interesting topics for your legal reasoning. Thank you so much.